The number you have reached, 911, has been changed to a non-published number.
Hi there, I'm Ken Lammers and welcome to CLTV. This week we're going to go through, well, 3 separate different subject areas: true stories, news stories, and practical theory. And different blog postings that I found interesting under each of these titles this week. Oh wait, we're also going to go through a section real quick at the end. And then we're probably going to end up with something from Dr. Horrible about Captain Hammer. And with that, let's get to it. Let's start out with the true stories of the week. And at number 7 is Policeman's blog. And it's a policeman from over in the UK who is in Canada apparently right now. And he's talking about how police cars are in Canada and how he apparently is in a place where it's pretty sophisticated, because he's describing things that we don't have in our local police cars. And then we're going to, have opinion will travel. Have opinion will travel is talking or is pointing us to a video of a gentleman who was pro se and went through the trouble of pretending to have a heart attack, and how the judge just wasn't buying it. So next we get to Ipsy Dixit. Ipsy Dixit asks that age-old question. If you set a trial date, you tell the prosecutor the trial dates that you're going to be ready for trial on the trial date, and the prosecutor tells the judge, I'm not going to give her a discovery before that trial date. Can the prosecutor then say that you can't announce ready for trial? I've not tried that one yet. That's an interesting thought. After that, we get to bad court thingy. And bad court thingy is is talking about domestic court and how the defendant in the case wants to talk to the victim in the case, because, it's a family decision what you're going to do in domestic court. And anybody who's done domestic work has been in this situation, I guarantee you. Well, then we get to our top 3 and start out with a public defender. And a public defender is talking about a case wherein a judge, after the jury has retired, orders that the defendant have a drug test, and apparently was going to give the results to the jury if they got back in time, which they didn't, or they got back before the drug test was finished, and the judge even left before the drug test was finished. That's interesting. Now, I've seen plenty of judges order on their own, sua sponte, a drug test or alcohol test for defendants that were in a courtroom. I don't think they're out of line doing that if there's behavior that shows that it's called for. For one thing, it'd be contempt to come to court drunk or high. For another thing, can the person actually be available to help their own defense attorney, etc., if they're drunk or high. So then we get to our second biggest story, and the second biggest story comes from a Missouri criminal defense lawyer who's talking about the great raccoon caper when he was a prosecutor, and how he was going to get that guy for having a raccoon at his house. And our biggest story of the week comes from, Wendy Pundit. And over there, Mark's talking about a story about how he ends up getting his traffic citation for not pulling off to the far lane or slowing down when he passed up pulling the far lane when he passed up an officer who had somebody pulled over. This is a serious consideration, and a lot of places have passed laws trying to make people do the right thing, because, if anybody knows any troopers that have worked around the D.C. area, Northern Virginia, I'm sure it happens in D.C. and Maryland as well, it's everybody knows stories about somebody that got hit. But be that as it may, Wendy is talking about, or Mark's talking about how he went in, did his bit, got his punishment, and then, despite the fact that he hadn't been told what was going to happen, he got his license revoked, and it was done in a discretionary matter in a part of the statutes that was hidden outside of the criminal or traffic law area, which gave the DMV power to do this. Department of Motor Vehicles pulled his license, and he talks about going back into court and how the prosecutor and the judge, who both probably didn't even know that was possible, then did something so that he would be able to get his license back. Don't be too hard on them, Mark. You know, when they hide those things where the DMV, you know, enabling statutes and stuff like that, you know, your attorney probably knows criminal law pretty good, probably knows the motor code pretty good, but then you get something that's hidden in the DMV section and sounds like probably isn't all that enforced very often. Well, you know, we all learn lessons the hard way. So, let's move on to our next section. In this section, we're going to talk about stories that have made the news, or actually kind of reporting of the news by blogs. And we're going to start out, well, number 7 is Faculty Lounge, where we're told we're told that if you're in the military and you write racist things on blogs and other places on the internet, that's not enough to get you in trouble. I think that that's a wrong decision, but apparently there's a court out there that disagrees with me. We'll see. Next we get the number 6 slot, the 9th Circuit blog, and 9th Circuit blog actually made it on twice today, and this one's the first one is, well, the question is whether Platonic duality requires downward departures in federal criminal law from the guidelines. And I'll leave it to you to go read the blog posting. At number 5, we have the Kentucky Law Review, where a prosecutor writes a letter, and apparently I think to the Courier-Journal, saying, you know, these are the reasons we put people who are on probation back in prison. And this is all part of, because Kentucky's having such budgetary problems, they're throwing people out the backside of the jail and doing strange things with probation and all that. And the prosecutors are trying to fight back against that. And next we come to the 9th Circuit blog again, in the number 4 slot. And it's about an ID case where Mexican gets caught with a fake ID and they try to give him a mandatory 2 years, and the issue becomes whether or not you have to know it's somebody else's ID, and you do, according to the 9th Circuit. You have to know it's somebody else's ID to get the mandatory 2 years, and as opposed to just fake ID. And there's also a kind of twist here in that the defense totally missed this, filed a bunch of other motions, but missed this point, and it was brought to their attention by the judge, at which point they filed the motion. The judge turned it down, said it was too late, and they filed a written motion later, and the Court of Appeals said, no, they preserved it. Okay. At the number 3 slot, we come to the SCOTUS blog, and the SCOTUS blog is talking about how Mexico has not yet given up on the World Court, and has gone back again and gotten the World Court to say again to go back and retry these, well, 5 I think in this case, people who are on death row, and you got to go back and retry them. They weren't told of their rights under the Vienna Convention, and you know what? It's already been settled by U.S. constitutional law. There's nothing that enables this under U.S. constitutional law, and the states are going to ignore it, and the court has now engaged in some undercutting its own authority by, well, having an order, an edict, that it knows won't be enforced. It's kind of a shame. At number 2, we get Simple Justice, who is telling us about problems with DNA. Because apparently all these statistics, which we've all heard about DNA over the years, 1 in 12 trillion, possibility, may not be as true as they'd like us to think. And he goes through a little bit about how it was kind of based on guesstimates to begin with, and one researcher may have actually shown that it ain't quite so. And finally, the story of the week. And I'm sure you all have heard this or seen it somewhere. In Q&O, we find out that Heller was turned down for his gun permit. Because his was a bottom-loading firearm rather than, I guess, a revolver. And because it's a bottom-loading pistol, it's a machine gun. Holy cow. What would possess you to do that? First of all, that's the dumbest thing I've ever heard in my life. If you really want to be technical, everything's a machine gun. They're all machines. But, okay. You've got to think a little bit. First of all, I know that DC is trying to bear as close to the line as it can, and it's going to end up in court again and again on these issues, I've no doubt. But what runs through your mind when you think, this Heller guy, I know he took us all the way to the Supreme Court last time, but I just don't see it this time. I don't think he's going to do it again. You've got to be kidding me. Well, on that note, let's move on to the next section. So let's talk about practical theory. And practical theory, we're going to start out at the number 6 slot. There weren't really 7 this time, but number 6 slot, concurring opinions. And it talks about a case where apparently the local federal district court judge got remanded or got in trouble because, well, he took the words that were used by by one of the party that won. Not terribly surprising he would do this, and it's kind of a weird thing to do. But, well, who knows with the federal courts sometimes. Number 5, we got the briefcase. And briefcase is talking about statistics on black crime and incarceration rates and statistics on campus rape rates and how, can we trust any of these statistics? And, I'll leave it to you to read. Number 4, we get public defender dude, who is defending the exclusionary rule and also pointing out that it's dang hard in court to get anything excluded. So, he's not sure what the effect is. Now, I personally actually think that the exclusionary rule does work somewhat in that, at the very least, it sets policies for various police departments that they try to uphold. And yes, I know there are police officers that try to break these policies, etc., etc. But the ones I've worked with, in general, try to toe the line. At number 3, we've got a two for one. We have Grits for Breakfast and Simple Justice, talking about how a judge allowed a search warrant for a defense attorney's office to get a piece of evidence, which there was going to be a hearing on, like within a few days apparently, to see if the defense attorney had to turn it over. So basically, there had been no hearing to say that he had to turn it over, and the judge let him have a free pass to go in his office. I'm not there with this. Now, mind you, if it's inculpatory evidence, which if the defense attorney has inculpatory evidence in his hands, he's ethically bound to turn it over. And so I have to assume that this defense attorney did not think that this evidence was inculpatory because he didn't turn it over. So, and if there's an argument over that, well, then the judge gets to decide that issue. And who knows? Well, at number 2, we get HCDL. I refuse to say that whole name, it's too long. And Seeking Justice. And they're debating over a question in voir dire, or or however you want to pronounce it. Jury selection, if we want to actually use English for some reason. And it's a question asked by prosecutors. If we present only one witness, but based on that witness's testimony, you believe beyond a reasonable doubt the defendant is guilty, can you convict him? And the, obviously if the person says no, the defense or the prosecutor moves to exclude that witness for reason, because that witness has said even if he found evidence beyond a reasonable doubt, he can't convict a person. And both HCDL, Mark and Tom go back and forth on whether that's a legitimate question. It's interesting reading. I actually think it is a legitimate question, but I think that Mark brings up an interesting point that it's not really to see whether or not somebody can convict somebody beyond reasonable doubt. And finally, again, HCDL, and it's Mark, and he's going on about talking about how, what do you do if a judge calls you up to the bench as a defense attorney and says, is your client guilty? Okay, and there's some back and forth over the legalities of it, because your client's not guilty, he's presumed innocent until such time as he's proven guilty and convicted by a jury of his peers. So you can answer, oh, I know he's not guilty, judge, or yes, he's innocent because he's presumed innocent. Now, of course, judges don't always ask it that way, and I think you're more likely, if somebody was going to break the law like this, be that far out of bounds, that they would say something like, counselor, did your client do this, or are you going to waste my afternoon? And at that point, it's a tougher question to answer. Because you can't say he's innocent, and you can't say he's not guilty there. The question is directly whether he did it. Never seen a judge ask this question. Can't picture any judge asking this question. It's so far out of bounds. Now, the question which might cause more problems for a defense attorney is the question which I've seen a number of judges ask. Counselor, what's your client's record like? Because clearly, if you put that evidence out in front of the judge, you are, you're hurting your client. But on the other hand, you can't lie to the judge about it. So it's back and forth. Actually, I've seen this a lot. Some defense attorneys answer the question. Some defense attorneys say, Judge, I don't feel comfortable answering that question. I think the prosecutor should answer it. It's kind of interesting. It's a little bit tougher question, I think. Well, and that's the end of our practical theory section, folks. Next we go to the section. And so now we start our what section. And this is from Simple Justice. And anybody who's been following Simple Justice has seen Scott over and over again talking about how professors are out of touch, and they talk about things which really don't have a whole lot of play and tactical grounds or anything like that, and aren't really useful in court. And then Scott goes off and posts something about Scalia and emanations and penumbras and all that in the Supreme Court's decision on self-defense, Heller, basically. And none of which has practical application. Basically, is self-defense a part of the Constitution? It's not written in, therefore it must be an emanation, penumbra, or else, as somebody pointed out in one of his comments, the Constitution is overlaid on the rights, and it is on the parts of the states, speaking for their citizens, a forfeiture of certain rights. So, therefore, it's not really giving someone the right to self-defense. It is a recognition in the natural law of self-defense. Okay. Personally, and I keep telling people this, I'm a textualist, so this is all silliness. You read the plain text. First part of it tells you why they put it in place, but does not put any constrictions upon the second part. And the second part says, the right of the people to keep and bear arms shall not be infringed. No conditions. It doesn't say for self-defense, for hunting, for defending your home and hearth, or going to war or anything. It just says, shall not be infringed. And that answers the question. Pretty plain and simple, actually. So, well, that's what I have to say about that. And ladies and gentlemen, what we're going to close up with, I had thought about doing something about the Batman film, because the big Batman film came out this week, and I thought it was a pretty good film. But then, yesterday, Dr. Horrible's video blog came out. And the big hero is Captain Hammer. Always loved that name, Hammer, since it's a name I've used and had as a nickname before. And so, I'm going to let you go with a picture of Captain Hammer and a little bit of a taste of what goes on in the video blog. Enjoy.
Stand back, everyone, nothing here to see. Just imminent danger in the middle of it, me. Yes, Captain Hammer's here, hair blowing in the breeze. The day needs my saving expertise.